Hey everyone, I'm Danny Rivera Jr., and you're watching Rights Watch. Okay, so a federal judge just blocked the Trump administration's attempt to move forward with mass layoffs across multiple federal agencies, stopping reorganization plans that were already in motion. It's a big development for federal workers, especially those who've been left wondering if their jobs are in the line. To help me break all of this down, I've got here with me, joined today by federal employee rights attorney Andrew Weeks. Hey, Andrew, how are you doing today?
Hey, Danny, doing good. Thanks for having me back on.
Hey, thanks for being here, brother. So there's a lot to unpack here over in this today's episode. There's a from the government executive, they've got a post here that talks about that most major agencies are now indefinitely barred from issuing mass layoffs. So I think it's important that we talk about that today and dive in a little bit deeper on it. I know we talked about the preliminary injunction last week, but now there's talks about an indefinite bar on these actions. What does this mean from a legal standpoint, Andrew?
Well, it's a 51-page order, so it's a lot to unpack. And I'll also note that the order's already been appealed by the government to the Ninth Circuit, and they've already filed a emergency motion for stay to pending the litigation, pending the appeal. That's a 29-page order. So, or 29-page motion, excuse me. So there's a lot to unpack. And honestly, there's a lot from a legal perspective where I could sit here and talk to you about it all day, Danny, and I could talk to you about it all day tomorrow and still not unpack everything in this 51-page order and the government's 29-page emergency motion to stay pending in the Ninth Circuit Court of Appeals. But overall, a good development to get that at the lower court. It's got a long way to go, probably all the way to the Supreme Court.
Right. So, right for now, it's good news because it means that the attempts right now, they were going real so quick that they were trying to do things in a quick manner, and sow chaos just about everywhere. They want to confuse people. They want to create chaos. They want to do all these things just to be able to try to get away with all the things that they're trying to do, right, as fast as possible, and as disorganized as possible. I think there's they are very methodic in the way that they've been disorganized with all these things that they're doing. Now,
well, Danny, to quote Judge Ilston's order from the first page, the court and the bystanding public should just move along. That's what the defendants are arguing. That's what the government's arguing with these rifts. Just move along. Nothing to see here.
Right. They're trying to make it seem like nothing's happening. It's not a big deal. We're not doing anything. It's not going to affect anything. And ultimately, they're not thinking about, not just the federal employees in general, not just our federal workers, but also the efficiency of the government itself. We've got this branch, this thing that Trump created, the Doge, right? That it's supposed to help with government efficiency. However, all these things that they're doing, it's making it so that the government is inefficient, right? I mean, there's no point in doing all of this other than trying to make the government inefficient. And I just wonder why. I mean, I've got a pretty good idea as to why they want to make the government inefficient. But over in this article, they're talking about the constitutionality of these actions, and apparently this judge finds that the president is most likely overstepping his constitutional powers. And over there it says that the president must seek congressional authorization. Is that from a legal standpoint? Is that what's going on? I mean, can the president try to dismantle federal agencies the way that he's been trying to do?
And that's the crux of the order, in terms of the order states that they need congressional support, essentially, that they need they need to work in conjunction with Congress to institute these wide mass reorganizations. Obviously, the government is arguing the opposite, that this is simply agencies pursuing RIFs on their own, um, and pursuant to the president's policy, they admit, and pursuant to guidance that they're getting from OPM and OMB, but that essentially these are just the agencies engaging in normal RIFs, and that they don't need congressional input. And it's interesting, to your point about inefficiencies and everything like that. If we sort of go through this before we get to the interesting part about the government's position and the arguments in the order regarding whether this was a directive or it's just guidance. But before we get to there, I thought the standing issue was very interesting in terms of how Judge Ilston found standing for the union, for the nonprofit organizations, and for local governments. And I think that's a good segue from what you were just talking about. For the unions, it's more than just these employees were harmed, because obviously the employees, they need to go through what their process is. There's a statutory scheme for these employees. No one argues that employees themselves can't file these lawsuits, right? These were not federal employees filing this lawsuit. It's the union, and the union alleges harm that will happen to workers, yes, but what Judge Ilston and their strongest argument was the union is going to lose dues. Right. The union's going to lose a lot of dues from this. The other argument the union made, I found very interesting, was that this was going to affect non-federal employee contract workers who cannot appeal to MSPB, right? They're not encompassed in that exclusive statutory scheme that a federal employee can appeal this through. So I found that interesting too. And then real quick, I want to keep chatting with you more about some of the other aspects of this, but the charities, the local nonprofits, or the nonprofits and the local governments, she found standing for at least some of them, at least some of the nonprofits, and she found standing for the local governments. I mean, these local governments rely on federal funding, and if you're riffing all these agencies that approve the grants, that supply the grants, that issue the funds, that manage this whole all this federal money incoming to all these local governments, who's going to be there to do it? And it can very much affect these local governments in a really negative way. So, in terms of efficiency, right, you're ripping all these departments and you're about to make the government less efficient. And based on that, she found standing for those local governments.
Right. I mean, I think we're talking basic common sense here. I mean, if you get rid of massive number of people and you're doing massive layoffs, if you're cutting off a huge portion of the workforce, let's take the VA for example, right? If you start stripping away and doing away with nurses, with doctors, because the RIF itself, it's not indiscriminate. It can happen to anybody. And I'm sure they would be looking at who most likely it's better for the agency to get rid of and who they don't want to get rid of. But if we're talking about meeting some quotas, some numbers, I've always thought that nurses and doctors are not exempt. At some point, you're going to run out of people that you can RIF from management. There's not enough people in management, although. I do think that we do have a lot of overhead on these agencies, especially in the VA. But there's not enough people that they can get rid of before it starts trickling down to direct patient care. So you start getting rid of people in services that we're already short, right? Some agencies say that we're overstaffed. But in reality, We're not. And you're going to find that most services are short. Most services don't have enough staff. Most services are running inefficiently right now, not because they want to, but because they can't hire people. And if they do hire people, there's a big probability that they're not going to be able to retain them. So it really hinders. And it doesn't affect just the employees. It hinders the services that we are offering to America. It hinders the services that the government offers to its people, to our veterans, to our communities. So it's not just about the employees. You harm the employees, you're harming the agencies, and therefore you're harming the American people.
Yeah, that's very true. And you know, that gets in a little bit of, and when I say standing from earlier, I'm meaning not just standing, but the injury part of it too. It's going to be a two-step analysis. So I say standing, but I'm really talking about not just standing, but the injury you have to suffer to be able to bring the suit and have standing. So you know, that goes to it, is that she found that yes, these local governments are going to be harmed. They had affidavits from different local governments about the amount of money they get in federal funding. About they had affidavits from some of these local governments that get funding from the CDC, and that they rely on this. Their public health system relies on this, and since all this has happened, they've not received that funding. So that's the very real harm that you're talking about. That they put the evidence up. That they put that up for her to grant this preliminary injunction, and we have those declarations, and she references that in her order.
Right. And you also mentioned something that that it's based on recommendations, and that they're arguing that they're, the rifts themselves, they're not real. They're placing the blame on the agencies rather than taking accountability for what they're doing. But over in this article, it talks about how some agencies have even recommended that that they don't recommend any layoffs, right? So it seems like the government right now, it looks like they've been overruled by OMB, OPM, and Doge. They're trying to go above them and telling them that you do need to get rid of some of the people, right?
And that was a big point in Judge Ilston's order. And frankly, if you read the government's motion in the Ninth Circuit, that I think the plaintiffs at this point, the appellees, right? Because they won, so they're now defending the appeal. But the plaintiffs, the local governments, AFG, the local unions, their response is due tomorrow. So it will be interesting to read their response to this. But if you read the government's motion on its own without the context of the order they're appealing, it looks like, oh man, this judge got it wrong. Oh, what happened? But then you go and read the judge's order, and you can really see she actually addressed the issues they bring up are, to me, appear to be a little misconstrued from what she actually said in the order, and how she explained it in the order. So when we're talking about Doge and OPM and OMB and the guidance they get, the government's saying, no, this is just policy. This is just guidance. The judge references that she read in-camera documents that the government is claiming deliberative process on, that they don't have to show these very important documents that are going to be important to any employee appealing risks from any of these agencies, that were their plans. She mentioned that in camera, it appeared that any plans submitted by the agency had to be approved by OMB and OPM. And that was an important note. So it wasn't just guidance being done, and then these agencies did these risks with, like, pursuant to the president's executive order and policy, but not a directive. And it's just guidance. No, it was a directive, and these plans had to be approved. And, the unspoken thing that Judge Ilston can't talk about, and that we know, the unspoken part of this is that, so the president gives guidance. He gives these OMB, OPM, and Doge instructions. He gives this executive order. And they're just like, well, it's guidance. The agencies can do what they want. But we know the reality the reality is you can't just do what you want when this president's asking you to do something. I mean, we are talking about an administration that has lashed out at individual cities. It's lashed out at law firms. It's lashed out at companies. And it's lashed out at judges. So no, I don't think that it's as simple as just saying, well, this was just a suggestion, it's guidance. This is something that you should have been doing,
Right. They're being disingenuous and the way that they're wording this out, because I mean, it's really unfair. If I was the head of an agency and you're telling me, oh, I would highly suggest that you get rid of 30% of your employees, I would take that as you either do it or you're going to get fired. I mean,
Yeah.
there's a real threat out there for these people to, and there's no incentive for them to not follow through, because they look at what's going around. Like you said, they're going after everybody, and they don't care who you are. They will go after you if you don't do what they say.
The term make them an offer they can't refuse comes to mind.
Right, right. Now, before we continue, I just wanted to remind everybody we have a big amount of our people that watch over Facebook, and thank you very much to everybody that watches over Facebook. But if you watch over Facebook, please, I encourage you to also head on over to YouTube, youtube.com/@RightsWatch US, where you can find our channel over there. You can support our channel by heading over to YouTube and subscribing over there. And then please just share this video with everybody, because I think it is very important to share information between federal employees, between everybody, so we know what we're up against. So just a quick reminder for everybody on that. Now heading back over. Now, does the president have the power to ignore these agencies whenever they say, "Oh, I don't think I need to lay off anybody. I don't think that's necessary." And that's going back to what we were saying. Do you think the president has the power to ignore the agencies when they come back and say, "No, I don't think we should lay off anybody"?
Um, that that's above my pay grade in a way, because I'm always going to be on the workers' side, and
Right.
I represent the workers in some of these reduction in force actions, and so all I can say is that Judge Ilston made it really clear, and I thought it was interesting that she talked about how you do these mass reorganizations of agencies, and how multiple presidents in the past, uh, both Democrats and Republicans, have sought to reorganize and either sought congressional approval and were not able to do it, or worked in conjunction with Congress to do these reorganizations. And this is the first time that the government is now arguing, no, we can just do what we want. It's the president's policy. He's in charge. As long as we're not eliminating statutory positions, we can do whatever we want, right? It's the policy, right? And if we can't do whatever we want, it was just guidance anyways. It's the agencies doing what they want. So this is a novel argument that's coming up. It's a little different than we've seen in the past. I found it interesting. Judge Ilston actually quoted old Heritage Foundation memorandums in her order to show why the preliminary injunction was necessary. She's kind of using the words of the architects of these RIFs against them. And it's interesting because the actions that the government is arguing now that the president can take, that the Heritage Foundation and people like that are supporting, were the same actions that, if taken under previous Democrat administrations, would have been sued immediately, arguing that the president exceeded his authority. So, in terms of what is the president's authority to ignore or not ignore, I think the president has I think what we're looking for is consistency. You got to play it the same both ways. You can't be making arguments under one administration that the president has and agencies have no authority, and then now under a new administration, all of a sudden the presidents and the agencies have broad authority to essentially do whatever they want. as long as they're not eliminating statutory positions, which we can't get into that today, but it's my understanding that yes, actually statutory positions were eliminated.
Right, right. It's so hypocritical. Whenever somebody else is doing it, you point a finger at him. Whenever you're doing it, all of a sudden it's good. It's okay. We can do it. And it doesn't matter, whatever we've said on the past, just forget about it because, if we do it, it means that we're doing it right. So they're always going to make the argument that they are within, their legal authority to do it or not. They don't care if it's the right thing to do. They don't care about the consequences of what they're doing. I don't think they've thought about thoroughly about what the effects of all of this will be, other than let's get rid of the majority of the people in the government, just as a means to give people what he's promised for in his campaign, right? He's promised a lot of these things throughout his campaign, shrinking down government, but there's no real thought process behind all of this, which is sad because ultimately who's paying for this will be the American people. So before we dive in a little deeper, let's go into a quick commercial break and then we'll be right back. Accessing legal representation shouldn't be hard, and neither should be accessing your own businesses, your platform, your voice. That is why I created Riversites, a powerful website creation and design service built for big and small businesses alike. Whether you're a union, a nonprofit, or a small business owner, we've got the tools to bring your mission online beautifully and affordably. Right now, we're offering 10% off for unions and legal services when you sign up for a multi-year plan. Just head over to riversitehub.com/fight4rights to schedule your free consultation today. That's again, riversitehub.com/fight4rights. Let's build something powerful together. All right, Andrew. So let's look ahead a little bit now. We talked about a little bit about the appeals process. You touched a little bit about this administration's appealing these actions. Now, what else can you tell us about their appeals process? Like, what is that looking? What should we looking at when we're talking about their appeals?
They filed their emergency motion. They appealed the order and filed their emergency motion to stay the order, to pause the order, essentially, so they can go ahead and continue with these RIFs. And ultimately, this is going to end up before the Supreme Court in some form or fashion, I firmly believe. But a big issue in their motion was that OPM, Doge, OMB, they interestingly don't really mention Doge very much in their motion. They more focus on the OPM and OMB memorandums, even though Doge was a big part of the order, not a big part, but it was mentioned in Judge Ilston's order. But it's very interesting because they're saying now, like, no, as we touched on earlier, this is guidance. This is guidance. It's all guidance. There was never any directive. The agencies are just doing this on their own with some guidance pursuant to the president's policy. And when we really look at it, and I want to go back to Judge Ilston's order, because if you read that in a vacuum, you'd be like, oh, okay, well, I guess, maybe the government has a point if you read it in a vacuum. But if you go and read it a little more detail, and I'm going to share my screen here with you, on page 38 of this 51-page order by Judge Ilston, and if you can see where I shared the screen, and I'll zoom in just a little bit, she talks about that the OMB OPM memorandum interprets the executive order as a directive. The executive order, quote unquote, directed agencies to eliminate waste, bloat, and insularity. President Trump required that agencies' heads shall promptly undertake preparations to initiate large-scale reductions in force. President Trump directed that no later than March 13th, they develop their reorganization plans. And the memo specifies that each agency will submit their phase 1A RRPs, which is their plan for the RIFs, right, to OMB and OPM for review and approval. So not on their own, they have to get it reviewed and approved by OMB and OPM. And it goes on to focus on a lot more of the directive language from the executive order and the memorandum. So when you read this, that was important to Judge Ilston. And you can see here, if you start on page 38, it's an interesting order. Like I said, we could talk about it all day today and tomorrow and go into depth. But that stuck out to me.
Right.
Because that directly addresses an issue in the appeal. Now, an appeal, they're saying it's guidance, kind of against the direct language, as we've talked about. One last thing with that, it was interesting that they completely did not include any mention of Doge. I didn't feel like in the motion. I'll have to reread the motion to say for sure, but nothing about Doge stuck out in the government's emergency motion in the Ninth Circuit. But Doge was included in the order, and she noted that Doge has no statutory authority to do anything, because this is a big deal of like if you need Congress to help you out with this. And as I mentioned earlier, where we had the Heritage Foundation being cited in support of Judge Ilston's motion. And the Heritage Foundation's memorandum talked about how 9 presidents, including both Republicans and Democrats, since President Hoover, have sought to do these mass reorganizations and gotten approval. And most importantly, the Heritage Foundation stated in one of their legal memorandums, she cited in her order that, quote unquote, sweeping reorganization of the federal bureaucracy requires the active participation of Congress, using their own words against them. And that's at page 31 of the order. So those are a couple things that stuck out to me. One last thing, as we're talking about the appeal, is they really do get into the statutory schemes that employees are bound by. If you're an employee facing a RIF, you need to appeal that RIF through the processes you're supposed to, whether it's the negotiated bargaining agreement, or if you're bringing, or through MSPB, or if you're bringing some sort of affirmative defense, then you can potentially just, even if you're a bargaining unit employee, you're going to be able to appeal that through MSPB. And without getting into all that, you need to contact an attorney. Okay, so there's a lot of attorneys, if you're facing a RIF, that are out here trying to help people. You need to contact one of them. It doesn't have to be us, but we are also helping people out with some reductions in force. And so you, as the employee, that's your exclusive way to do this. This isn't necessarily about just how it affects these employees. This is about how doing this without congressional input exceeds presidential authority and constitutional authority, and how then that injures not the employees, just the employees, the federal employees encompassed by the scheme, but also non-federal employees who are contract employees, but also entire local governments, entire cities, entire counties, people doing important work, and obviously the unions that are here to protect our workers' rights. So in that part of the motion, I feel like it missed the point of Judge Ilston's order, that no one's arguing that you as a federal employee can bypass MSPB or whatever process you need to use and go straight to federal court. No one's arguing that, although there might be an argument for that down the road, since MSPB does not have a quorum right now. And depending on what happens with MSPB and its funding, who knows? But I'm just saying, no one's arguing that. This isn't about the federal employees being restricted to the scheme. So that was another point in the appeal I noticed.
Right. That's why most of the things that are going on right now, and I don't think I've heard the word unprecedented so much in my life, other than when this administration's taken over. I think since the first time they took over, I've been so familiar with this word.
Oh my God, it's the most overused word, but there's no other way to describe it. I will apologize when I'm giving advice to employees on reductions in force and how that's affecting them and the options they have and how we do it. And I have to use the word unprecedented so many times because a lot of questions we have, we don't know. We're
Right.
finding this out now because this has never been done before. So what is the precedent for this, right? A lot of the precedent for this is being made right now, and this is going to be the
Right.
precedent cited probably years into the future if issues like this ever come up again, because we've never seen anything like it. So
Right.
yeah, the most overused word, the word of the day is overused, because that's what unprecedented
Unprecedented.
is.
Yeah, I think I mean we're facing so many challenges. I don't think we've ever faced on our legal system in general. I mean, I've heard people even talk about a constitutional crisis, but we're not going to get into that today. But I mean, there's so many things that this current administration is doing that's causing so much chaos and confusion because we haven't seen anything like this in I mean in forever. And again, if other presidents have gone through Congress, if other presidents have done it the right way, and I think that just shows leadership. When you go and do things the right way, right, instead of bullying people, instead of pushing people over, you try to do things the right way. You go through Congress. You take the steps to make sure that everything that you're doing is within the legal boundaries, right? I think that shows more leadership than pushing people around and making them do your bidding. So and then again, that's why it's so important for us to keep continuing this fight, keep pushing towards defending our rights, right? That's why they don't want us as unions. That's why, I mean, that's why they've gone after judges. That's why they're going after legal firms. That's why they're doing all these things. They want to silence the people's voice.
Right. And we need strong leadership. And it's unfortunate because I always joke with, but not joke, I tell the sad truth to clients when they come to me with issues. And I say, well, that sounds like they're a terrible manager. And that they're a terrible manager to everybody because you're talking about how everybody in your office
Yeah.
can't stand this manager and all these terrible things they're doing. And I'm like, you know what? But it's not illegal to be a bad manager.
Right.
It's not illegal to be a bad manager. Now, it's illegal to do unlawful things, but it's not illegal to be a bad manager. And
Right.
ultimately, when we get back to that, this is about, was the president's actions lawful? And you can't scapegoat that by saying it's just guidance. As we saw, it's not just guidance. This was a directive. The
Right.
memorandum said it was a directive. This was straight from the top. So let's skim back that. You got to skip past that part. And ultimately, it's just, was the actions of the president lawful? And Judge Ilston determined they were not
Right.
and issued the preliminary injunction. How this plays out in the Ninth Circuit, how this plays out as it ultimately, I'm confident, will reach the Supreme Court. I don't know. I don't know how it's going to play out. Obviously, I can sit here and conjecture and all that. But again, ding, 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 unprecedented. I don't know
Right.
how it's going to play out in the end.
Right. Yeah. It's just, they're just right now, it's just a play on words, just to go around the legal boundaries and the current precedents that we have. So, it's all right now, what if, but I think, being a little optimistic, I think there's judges out there like this one judge that do actually care about the legal system and they want to make sure that whatever decision's been taken, they're taking these decisions through the right means.
And we got to try to have faith, because what I've found out is that there's judges out there who are really doing good work
Yeah.
and really listening to things from both sides of the aisle, even though judges are non-political. But I mean judges that might have been appointed by Trump, by Biden, by Bush, by Clinton, by Reagan. There's judges out there from all spectrums that are really trying to do good work and really putting their ears to the ground. And so we have to respect that. Do we always agree with it? No, but as attorneys, we have to respect that. And I hope that this plays out the way it should. And I think Judge Ilston's order was a good step. And I think that regardless of whether you're from the opposite side of the political spectrum and you disagree with everything that she says in her order, I think that no one can deny that she looked at this issue, she looked at it carefully, she did the work, and she issued a well thought out decision that's sound. And now, whether you agree with it and you're going to appeal it and maybe went on appeal, that's one thing. But this 51-page order wasn't just some, oh, it's some liberal judge. No, this was well thought out.
Right.
And orders have come out from judges across all, even from judges appointed by Trump in his last administration, have issued orders against him, so we have to have faith that there are judges out there who are going to do their work, whether it's MSPB judges, EEOC judges, federal judges. We have to have faith. So that's my parting closure, and you have to keep fighting. That's what you got to do. We got to fight the good fight.
Right. That's right. And that's what we're doing. We're going to keep fighting till the end, Andrew. So again, Andrew, I really appreciate you being here today and walking us through all of this. It's massive chaos, but it's been
my pleasure. It's been my pleasure. I'm sorry Whitney couldn't join us. Much like the Eagles celebrating the Super Bowl at the White House, we were missing our star player from Legal Justice at Work, Whitney Raley. But I appreciate you having me on today.
Of course. I can't wait to have you back, and I can't wait to have Whitney back again. To everybody that's listening, this ruling puts a pause on mass layoffs. Okay. It doesn't just mean that the fight is over. This administration is pushing back, and the agencies are still trying to maneuver around the ruling in other ways. Okay. So it's important. It's more important than ever to stay informed, stay organized, and stay involved in what's happening around you. If you're impacted or even concerned, reach out to your union. And most importantly, seek legal guidance. Don't just wait until it's too late. Andrew, where can folks go and reach out to you if they've got any legal questions or they want to know more about your work?
Yeah, sure. I think the best place to go is our website, www.legaljusticeatwork.com. Actually, I think these days you don't even need the www. It's just legaljusticeatwork.com. LEGALJUSTICEATWORK.com. Whitney's and I's information is on there. Our cell phones are on there. Our emails are on there. There's a contact form, and we have Calendly on there, so you can actually schedule an appointment without ever even picking up the phone. At 3 a.m. if you have to. I literally have multiple people schedule appointments with me at 3:30 a.m. They're up late, thinking about what's happening, thinking about their federal jobs, thinking about things like that, or they work third shift, and you can reach out to us anytime.
Awesome. All right. So, and we have that information over in the description below. So if you're watching YouTube, you can go ahead and click on their link so you can reach out if you need legal assistance from, I would say, truly the best. So it was very helpful. Andrew, thank you very much for being here again. For everybody that's watching, share this video with your coworkers or someone that needs to hear it. If you want to support the show below, check out the links in the description. Until next time, stay informed, stay organized, and remember, we are not giving up.